Hi, everyone. Welcome to episode 163 of the Immigration Lawyers Podcast. I want to thank you again for joining us. It's been a lot of fun, and a lot of new members have been contacting me about listening to the program and how much it's helped them. And it's always much appreciated knowing that you're out there and what effect it has on your lives. It's really a blessing to be able to be put in this position. And I'm just always so excited about sharing this information that I decided that I'm going to publish, and I am publishing a magazine, at first an e-magazine version of the Immigration Lawyers Toolbox. We have over a dozen colleagues participating and contributing articles, and it's going to be a lot of in-depth information analysis at the beginner and intermediate expert level of different levels of immigration practice, from humanitarian to court to investment-based immigration, family, employment, all the above, stats, charts, marketing information, and a way to get to know your colleagues and all the achievements and success we're having in that magazine, a trade magazine that's really needed in the practice area that we have. So I'm looking forward to that. If you're listening to this and you're not part of the Facebook group that's for private lawyers, just email me. You'll get on the list for getting this when it comes out. And if you're a paralegal, this is open to everybody. It's really garnered for immigration practitioners, but I know there's a good population of people that just are interested in immigration and they like to learn about this stuff. Let me know and you can get access to it. I'll send you the link when it comes out. Also, if you're a paralegal, because again, we have a lot of paralegals listening too, I'm making a classifieds page for it where you could list your paralegal, your contact information, and the type of cases you take. And so that listing may be interesting. It's a paid listing, but email me at info@immigrationlawyerstoolbox.com to get information how you can put that posting. This is going to be in the front of thousands of immigration lawyers that have access to it. So I think it's a great place to get your name out so they know that you're there, because I can't count how many times people contacting me that they're looking for immigration paralegal, and I don't have one on the spot. So being on the listing is good. Just, maybe make a website, have a link to your website. Maybe you're something easy for them to be able to look up your background too. But it's a cost-effective way to get yourself in front of a lot of practitioners. Another thing is I want to thank our sponsor, DocketWise. Please go to www.docketwise.com/immigration-lawyers-podcast. And the code for that is Immigration Lawyers Podcast, where you can get 10% off the annual plan, which I strongly recommend. It's the plan I personally have for my law firm. And DocketWise is just adding every week we get an email or new things. They just added the ability to do payments through LawPay. They added like Portuguese language last time. They already have other languages. They have ability to text message your clients like questionnaires, and they have a timer on there, an invoice. It's a constantly growing thing. I think they're going to eventually take over everything. It's going to be all in one toolkit, but they got the primary thing, which is the immigration cases down, because it's a partnership, the ownership of it. There might be a corporation, but they're partners. One of them was a practicing. I don't think he's practicing anymore. But James Pittman is an immigration, once an immigration attorney, always an immigration attorney. And so he knows the stuff we deal with, and he's on top of the form changes. And that's always much appreciated. Someone who's been in the trenches and knows what we have to deal with. So DocketWise, again, is www.docketwise.com/immigration-lawyers-podcast. And the code is Immigration Lawyers Podcast to get an additional 10% off the annual plan that's already discounted. One last thing is, if you are you're listening to this, you like this, please like, subscribe, and leave a nice review, a 5-star review on the format you're listening to. It help out the program so other people can learn about it as well. So let's get started about what we're going to talk about today.
Welcome to the Immigration Lawyers Podcast, a part of the Immigration Lawyers Toolbox, an education and marketing publication for the immigration law community that includes legal updates, interviews, discussions, education and CLE material, and more. Note that the information here is for general education only and not intended as individual legal advice. The laws change frequently, so you should consult with an attorney about your specific case. For more information, please visit immigrationlawyerstoolbox.com.
A couple months ago in July, a report came out from the Ombudsman's office. And the Ombudsman's office is the group that there's different ombudsmen, but there's a Citizenship and Immigration Service Ombudsman. They kind of look after USCIS. They get their funding separately from Congress, and they kind of help us along the way. And a lot of practitioners don't even know this exists, but sometimes when cases aren't moving forward, and we'll give some examples, you could contact the Ombudsman's office and they will help you move the case forward. I've used them before too. And every year they give out an annual report of issues they've seen and what they've done, all this kind of stuff. This report is 122 pages itself. I wanted to do this podcast where I go over the report months ago, but because it's 122 pages, it's a go off for me to read it. But I did it now, and it's very interesting. There's stuff that's eye-opening that I think it's worthwhile for a good practitioner to know because of the possibilities of things, to get some behind the scenes inside baseball on what's going on. So this is the annual report for 2020. It was published on June 30th, 2020 by the Citizenship and Immigration Services Ombudsman under the Department of Homeland Security. It's something they give out to Congress to review. The beginning, there's a message from the Ombudsman. He says, the Office of the Citizenship and Immigration Services Ombudsman was created by the Homeland Security Act in 2002. Mission includes assisting individuals, employers in resolving difficulties they experience when seeking immigration benefits from USCIS and proposing changes. As this report is being finalized, USCIS is facing two significant challenges: the staggering reopening of its public-facing offices in the wake of the global coronavirus outbreak, and a budget shortfall that may result in furloughs. So this was in June. We all know what's going on there. The situation hasn't changed. We're still dealing with those. It goes on to say to test out his continuity plan to figure out how, because of the issues of shutdowns, they got to test those out. The importance of moving beyond paper processing is important for immigration benefits, and USCIS may want to intensify its efforts on implementing electronic filing and adjudication for all types of forms, a goal once set for the end of 2020. So the goal had been that by now, today, December 2020, they would be fully online, but that hasn't happened almost at all. Very minor programs that are online. He goes on to say, though USCIS has provided clarification and guidance on several issues of immediate concern, such as evidentiary response times and in-person interviews, as the COVID pandemic has lengthened, important issues remain unresolved. And there's some really messed up stuff where USCIS just claims stuff, even the Ombudsman. They're pretty impartial. They come out and say, this doesn't make any sense. So we're going to go through all of that. He goes on, the report covers a rapid increase of the optional practical training program, OPT, which enables approximately 200,000 foreign students to work annually in the US. And they have stats on this, and OPT really did rapidly grow. I didn't realize the numbers in the last couple of years are so big and how it's overwhelmed the CVIS system in general. They say the number of pending affirmative asylum applications now stands at approximately 350,000 affirmative asylum cases. That's wild. Despite USCIS's near tripling of its asylum staff. As always, the pressure is on USCIS to complete applications, blah, blah. In fiscal year 2019, it received 8.1 million applications and petitions. So that's a huge number. That's that 8.1 million applications. So, when issues happen, things get lost, you call them, they don't know what's going on. Their agency that deals with 8.1 million cases coming in. So that's going to happen. So you got to give it to that. The guy's name is Michael T. Doherty, the guy who wrote it. I think the Ombudsman was someone else she was like one of these FAIR people or those Center for Immigration Studies, something like that people, but they left and this gentleman came. I don't know much about his background, but let's jump into some information. So how the Ombudsman's process request for case assistance works. Anyone with standing applications, applicants, petitioners, legal, and other representatives may contact the Ombudsman for assistance with specific case problems at USCIS. There's no cost to submit a request for case assistance. However, because the Ombudsman is a resource of last resort, one should first attempt to resolve concerns directly with USCIS through its public service channels. And they say each request for case assistance is reviewed initially by one of the Ombudsman's senior immigration law experts to determine whether the Ombudsman's office has jurisdiction and to identify requests requiring expedited service. For example, our immigration law analysts regularly communicate with the Department of State's DOS National Visa Center to help with with difficulties getting the case transferred. So although they're a USCIS operation, they do deal with DOS. So when you have an NBC saying we don't have the case, we can't find it, you could potentially at the last resort after contacting that special email DOS has for cases. Can't remember what it was to tell you the email address, but NBC has some sort of email where if the case for USCIS is not going forward, you contact them with. But you can always at first go to the DOS contact us page and they might guide you. And there's a bullet point here that says if you're requesting expedited assistance, submit evidence of the urgency or hardship, medical records, financial documents, letters from employers, and how you will be unable to withstand the hardship. And so it's really important when you do an expedited request from them. They say, in addition to cases meeting the criteria, the Ombudsman expedites all requests related to employment authorization documents that are outside of USCIS posted processing time. So automatically, these are going to be expedite requests when the work permits are taking too long. So, I mean, 1 out of 10 cases, the work permit doesn't come. So you got to contact them, see what's going on. The Ombudsman's team of analysts has a wide range of expertise. Many have worked in USCIS adjudication roles, private immigration law practice, and positions in other federal agencies, such as the Department of State, Labor, and Justice. When the request contacting USCIS, when the request warrants an inquiry to USCIS, the Ombudsman communicates directly with the designated points of contact at field offices, service centers, asylum offices, and other locations. Each inquiry includes a request that USCIS review the file to ensure that both law and policy have been properly applied. And they have some stats. In 2019, the Ombudsman expedited 2,559 of the total 8,745 cases it received, 29% of them. More than half of the expedited cases were related to employment authorization documents. Now, they have a 2019 case in review. They say in 2019, the Ombudsman's case team had between 7 and 9 immigration law analysts and immigration case assistants who worked 8,745 requests for case assistance. So the numbers is kind of weird that they have only 9 people, or 7 and 9 people, between 7 and 9 people. So say 8 people. So that's a person, 1,000 a person in a year. Each one does 80 a month. Whew, I don't know how much work each one is, how quickly they do it, but that's a lot, and it seems underfunded. They say there was a decrease of near 23% in work from the previous year. They say as an office funded solely by the appropriations from Congress and not by fees from the public, the Ombudsman Office was closed for 35 days at the end of 2018 and beginning of 2019 due to partial lapse in appropriation. So here's a lot of examples that I think is probably the most interesting part about it all, to give you ideas. The following case examples are just a small sample of the types of requests the team completed in 2019. There was an erroneous denial where a pro bono attorney contacted the Ombudsman because USCIS erroneously denied a client's I-914 application for T9 immigrant status, claiming that the applicant failed to respond to an RFE prior to the submission deadline. USCIS considered the application abandoned and denied it. The attorney had correspondence from USCIS, as well as the Postal Service tracking information showing that the RFE response was in fact received prior to the deadline. The husband requested USCIS review the case, and they reopened it 2 weeks later and got it fixed. So that's one. Document loss abroad. An adjustment of status applicant, and this is really interesting because it goes to DOS again. An adjustment of status applicant lost his advance parole document while traveling in India and was therefore unable to board a plane to return to his family and job in the United States. While the applicant attempted other means of obtaining advance parole, he was unsuccessful until he reached out to the Ombudsman. Do you think you go to DOS and it would help you? Nope. In less than 2 weeks from the Ombudsman's request, USCIS had approved an emergency travel document and communicated with the DOS office abroad to complete the processing. Another one is delayed naturalization. An applicant for citizenship reached out to the Ombudsman when over a year had passed since her interview and test at USCIS. She had contacted USCIS several times to obtain an update, but without success. Thanks to the Ombudsman inquiry, the applicant was at her local office to take the oath ceremony less than a month later. And that's something that I get a lot of calls from people who pro se file for citizenship. They do their interview, months go by, and your instinct sometimes nowadays is to file a lawsuit, which you can. If you had your interview within 4 months, they have to make a decision. It is possible to do a lawsuit, but here's a less expensive way to give a shot first before you take that final try at it with the lawsuit. Another example is incorrect approval dates. An agricultural employer sought assistance when his Form I-129 petition for non-immigrant worker was approved with incorrect validity period dates, giving the employee less time to work for the company than requested. So that's interesting. You think like you just got to go by what USCIS gives you at the end. The Ombudsman asked USCIS to have a supervisor review the petition and supporting documentation from the Department of Labor. Subsequently, the petition was reopened and the validity dates corrected, giving the petitioner employer the agricultural help it needed through the season. There's another one, misclassification of status. After several unsuccessful service center requests and attempts to communicate with her congressman's office, an applicant for adjustment of status contacted the Ombudsman. Her application for a travel document was erroneously denied by USCIS. It now stated that she had entered the United States unlawfully or as a crew member in transit. The Ombudsman reviewed the applicant's documentation and database, and they found out she was a J1 worker, massive error. Another typographical error, an applicant contacted the Ombudsman office in correcting USCIS error of his first name on his receipt and approval notice, which caused difficulties not only for the applicant, but also for his spouse, who required a correct approval notice to obtain the visa needed to join her husband in the U.S. So the U.S. wasn't being flexible about it to understand that the typo. When the Ombudsman reviewed the case, it was discovered that the applicant's efforts to resolve the issue had resulted in the name being corrected in the USCIS database, but amended documents have still not been produced and sent to the applicant. As a result, the Ombudsman fixed that and had it sent within a week. So just USCIS has 8 million cases. I got to give them benefit of doubt sometimes, but it's on an individual level, it's very frustrating to deal with these kind of problems. That's what we're here for. Adjudication error. A petitioning employer requested the Ombudsman review the denial of an I-140 immigrant petition for alien worker. This was the second petition filed by the company. The first was previously denied due to a typographic error on the form. The second application was filed with a clear explanation that it relied on the previously submitted labor certification. Per USCIS policy, when a subsequent petition is filed after denial and the expired labor certification is otherwise valid, the certification may be used in the second petition. The adjudicator did not take this policy into account and denied the second petition for failure to include a current labor certification. At the Ombudsman's request, the petition was reopened and approved. And the last example they give, processing delays. The Ombudsman assisted an applicant for adjustment of status who had not received a decision 8 months after his interview. At that point, the application was beyond the posted processing time range. And now they've made the processing time so long that's like there's no way to be out of it. But upon the Ombudsman's inquiry, the field office located the requisite information, including the applicant's response to the RFE submitted several months before, and determined that the individual was eligible for lawful permanent residence. Notice approval came a week later. So year in outreach, it says in 2019, the Ombudsman conducted 85 stakeholder engagements despite the lapse in appropriations that resulted in the Ombudsman's office closing for those days I talked about. But one thing that popped in my mind is like 85, and I remember going to one of these in 2019 at the USCIS in downtown LA, but it's like, how do you have the time to do this when you have all these files? Stay in the office and work on the cases. We don't need outreach, but maybe outreach is important too. So USCIS's work during the COVID-19 pandemic, they say the pandemic altered USCIS way of managing its workforce and workload. A majority of USCIS employees turned to working from home. So a majority of USCIS employees are working from home right now. This has brought additional challenges because while the agency has made strides in electronic processing of cases, many applications and petitions still require paper files. The transfer and tracking of these files in the pandemic as adjudicators continue their daily activities has presented just additional logistical challenges. So that's an issue right there. And they have a lot of good graphs here. I'm gonna put these graphs up somewhere eventually. But the first section they go into detail about is about what they call the geometry of the naturalization background. They say the N400 backlogs has steadily increased in the past decade, but surged significantly in fiscal year 2016 and 2017, resulting in a pending inventory of 652,431 applications at the end of 2019. The shutdown of offices caused by the pandemic only made things worse. Unanticipated surges in applications were not met with additional resources. Let me repeat that. There's some anticipated ones that they didn't do, but let's say unanticipated surges in applications were not met with additional resources, although efforts have been made to create efficiencies while maintaining integrity. The strain of expanded interview requirements has impacted processing times too. So as you know, they're doing interviews for I-730, family of asylees. They're doing employment-based interviews now. They're pushing interviews for a lot of other categories. So that affects naturalization as well. Longer completion rates and lean staffing have also contributed to the increase in processing time. So in fiscal year 2019, USCIS naturalized 833,000 new citizens, its highest number since fiscal year 2009. That's an interesting stat. The increase would present a considerable challenge to meaningfully reducing the original backlog. They were trying, but the financial constraints avoid that. In order to simply keep pace with the incoming caseload, the agency must not only achieve a personal best, quote unquote, in completions, but also overcome a perennially challenging issue, lack of resources, by reconfiguring the way it processes N400s. So in 1990, this is going back. So it seems like back in the 90s when it was a separate backlog and serious issue that happened, they're saying that they lowered their standards. So a lot of mistaken people got citizenship, even people with criminal history or deportable. And so that's the thing that happens. Like, how much do we focus on make sure we do it right to avoid that happening? How much do we deal with the backlogs? Because it's an important benefit. People who get citizenship could vote and be full-on Americans, and that's not right to hold them back just because of agency backlog. So these two objectives are problematic. In 1995, faced with mounting application backlogs and external political pressures, the Legacy Immigration and Naturalization Service, INS, prioritized production at the expense of accuracy. naturalizing 179,000 individuals without a definitive criminal history check conducted by the FBI. Wow, that's something. Which resulted in the naturalization of 10,800 individuals who, quote, had been arrested for at least one felony offense. That's a lot, 10,800 felonies. Wow. The Department of Justice Office of Inspector determined that the INS's focus on quantity over quality resulted in inadequate training, reduced safeguards, and hasty implementation of unproven processing techniques. So they're trying to fix that with ELIS, but who knows what's going to happen there. They say USCIS defines backlog as a number of pending applications and petitions that have been in process longer than the agency's processing times. The agency further reduces the number by removing applications and petitions that are outside of its control, e.g., pending response to requests for evidence reexamination. So when it's really important, when they're calculating backlogs at USCIS, they take out cases that have RFEs pending. So the backlog is probably even longer than the numbers they put here because of the way the statistics are inventoried here. So that's something that was interesting that came out in this report. They say USCIS historically experiences a temporary increase in naturalization filings in presidential election years and when fee increases are proposed, followed by reduced filings in the next fiscal year. So I was somewhat surprised when USCIS projected a 6% decrease in naturalization from fiscal year 2015 to fiscal year 2019, despite an anticipated fee increase and the 2016 election. So that was really weird. So 2015, that was Obama time, I think. So they knew a presidential election was going to happen when the things go up. And there was a fee increase happening, which always does that. They put a decrease of 6% projected, but actual recipients were 25% higher than what was projected in the previous year. So in 2016. So it just who's running this show? how did that decision get made? In October 2017, USCIS expanded in-person interview requirements for certain adjustment of status applicants, blah, blah, resulting in considerable additional delays. So that was a messed up situation. Now, we all know citizenship's backed up, but then the problem comes, what about removal of condition I-751? The only thing worse than the citizenship backlogs is actually the I-751 backlogs for removal of conditions. They have a section on that. They say, in addition, the presence of a concurrently pending I-751 in an applicant's record appears to lengthen the M400 processing time. They explain what the I-751 is. Procedural hurdles. Officers are instructed to adjudicate the petition. So what happens is officers can adjudicate both the I-751 and 400 if possible there. But the COVID, I think it's gone stricter. But in the past, I would just say, hey, do both at the same time. They do it. They say procedural hurdles may prevent officers from adjudicating these benefit requests concurrently. So this is really important. For example, as USCIS is increasing moving to an electronic environment to process N400s, the physical file that contains the pending I-751 still in paper format may not be available at the naturalization interview. So that's the problem that happens. They have the file at the field office when you're doing your N400. Do they have the I-751 file or not? That could be a major issue in delaying things. In addition, an officer may wish to interview a petitioning spouse on a jointly filed I-751. However, due to time constraints or failure to notify the applicant to bring the spouse, they may need to reschedule and continue the case and push it down even more. Then they talk about insufficient staffing levels in facilities. Although USCIS has almost doubled its authorized staff since fiscal year 2009, it remains unable to process all cases within time projections due to insufficient staffing levels and facilities. The agency has also been unable to fill the authorized positions due to lags in the hiring process and the need to backfill existing positions, higher than anticipated staff attrition rates at certain field offices, especially now. Like, it's hard being a USCIS officer with the craziness going on. So the attrition is a serious issue. Declining completions per hour work is a major issue. Then they say, however, technical and functional difficulties in the rollout of the N400s and ELIS, as well as enhanced vetting requirements, result in longer completion rates. So, filing the N400 online, I still file paper. I did a poll on the Immigration Lawyers Toolbox Facebook page for private practitioners. I think around like 80% of practitioners still file a paper. The ones who do it online were adamant that it's better. I've tried doing online I-90s, N400s. It doesn't make sense to me. I'm not sure why it's so difficult, but I just stick with the paper and make it. But, we have to make the switch eventually. But here it says there have been functional difficulties in the N400. On average, it currently takes officers approximately 30 minutes longer to adjudicate the N400 than it did in 2010. So that's a major factor. When I started, the N400 was like 4 pages or how many pages? Now it's like 20. Some key factors leading to increased completion rates include the growing complexity of the naturalization adjudication process, issues with the deployment of ELIS, and the removal of numerical case production metrics for an employee evaluations in fiscal year 2014. So they don't keep track if someone's doing work fast or not and getting things done. Also in 2014, the length of the N400 doubled from 10 pages to 20 pages, which took more time to verify. However, as noted, certain field offices have exceeded their physical space capacity and cannot accommodate the additional staff even needed to increase N400 adjudication because the existing until the facilities are made bigger. So just there's practical components here that create a problem. Okay, workload shifts. The case transfers were based, so sometimes they transfer things from their field office. This was kind of messed up, and I haven't had to deal with this, but I've had clients to do this. But because one office is so busy, they're transferring the caseload to another field office, but the other field office could be really far from where that person is. The case transfers were based on a combination of zip code realignments, interviewer reassignments, continued case shifts, and other factors. For example, in attempting to reduce the N400 processing times in the Seattle field office, Seattle, Washington, USCIS shifted several N400s to the Portland and Yakima field offices. So Portland, Oregon. So Seattle and Portland, they're a couple hours drive from each other, right? Seattle, Portland. So I'm looking at a native over there. How long is how long is the drive from Seattle to Portland, do you think?
4 hours.
4-hour drive. I have a native from there. So that's obnoxious. I have no idea. Yakima's in Washington State, isn't it? Is that like the middle of Washington?
I'm sorry, I'm wrong. About 3 hours.
Okay, 3 or 4. It's like going to Vegas, essentially, but from LA. Where's Yakima? Yakima, Washington. It's in Washington. It's like inside the middle of Washington, right?
No, I thought it was
South, where the apple orchards are. Is that Yakima?
It's by the Indian reservation.
It's by the Indian reservation. And how long would you think that's a drive to go to Yakima?
From Portland or from Seattle?
From Seattle.
Let's say 2 hours.
Okay. I mean, traffic in LA going from 3 miles could be 2 hours sometimes.
2 hours, 14 minutes.
2 hours and 14 minutes. Oh, so that's pretty annoying, especially if you got to go to the interview and stuff. Okay, so due to the system limitations, USCIS was unable to provide the Ombudsman. This is really a weird situation. They say, due to system limitations, according to USCIS, they were unable to provide the Ombudsman's office with exact figures on the field offices that participated in the workload shifts, the number of cases that were transferred and completed, and the number of applicants who could not or did not appear for the interview at the new location. Notwithstanding, USCIS indicated that its workload shifts are a proven method of reducing wait times for the giving office. We note that the median processing times at the Seattle field office remain the same. So USCIS does give stats, but they say, no, we know it's good. And then they check the stats and the processing times and they're the same. So that was like let's just say funny thing. We recommend that the agency improves the ability to track and monitor its N400 workload. That's the recommendation. If you track this stuff, what's going on here? They go on to say, unfortunately, due to insufficient testing of the system, the initial introduction of the N400 in ELIS was plagued with issues. So that's we all know that. They go on to say, conducting the statutory naturalization English and civic test requirements at the beginning of the interview. So they're putting systems now of trying to make things faster. So one thing that they said is an idea is to do the naturalization English and civic tests first, because if they can't pass that, then don't go into the rest. And so that's one way maybe to speed things up that they said. Now, another recommendations. At the end of fiscal year 2019, only 3,187 N400s were pending with an I-751. As of December 2019, 3 years later, the number had increased to 34,491. So there's a 10x increase in 3 years with I-751s pending. As you all know, it's this craziness that I-751s are taking almost 2 years to be adjudicated. I don't understand how that is. I have a case that took 1 year and 3 months, and we submitted so much evidence. 1 year and 3 months to get an RFE, ridiculous RFE, obviously. And I responded with like 300 pages of information. I have to get a box to send the case back in. And it's been a month and it still hasn't been adjudicated. I mean, like it's beyond the shadow of a doubt that this couple is a real couple. How could it not take 10 seconds? I don't know. I got to see what's going on there, what's going on. But they go on to say, accordingly, I-751s are not a priority. Well, this is why. According to I-751s are not a priority for the agency because inaction does not delay the delivery of an immigration benefit. That's a ridiculous thing to say. That's their opinion. although it may complicate other things, including permanent residency proof for work and employment and the N400 benefit, which is citizenship. So I-751 is a critical document. So imagine you have I-751 pending. So they're married for 2 years. It's pending for 2 years. Near the 4-year mark, they get in a fight. They're getting a divorce. You know how much of a nightmare it is dealing with an I-751 when the couple is petitioning for divorce, but the divorce isn't filed yet? That could lead to denial or removal proceedings, drastic consequences down the line that they don't even take consideration. So that's, I deal with these cases. I'm just seeing the effects it has on people. So I have a very hard time taking that lightly, what their opinion is. They say, in addition to leveraging its technology, USCIS could provide supplementary guidance to officers regarding the overlapping eligibility determinations made for jointly filed I-751s and N400s. Obviously, because of bona fide marriage and a 3-year living together kind of stuff. So yeah, do the education, please. Requiring applicants to submit their N648s at the time of filing may help ensure ample time to officer review the case. So that might create some sort of better system, because right now the N648, that's when someone has a medical condition and they can't do the English language requirement, all that kind of stuff. Maybe making a more standardized system, because it's when you leave it up to officer, you're waiting until the end to see how that's possible. And if it isn't, if they deny it, then the case is denied. Why not figure that out at the beginning at the benefit center? The Ombudsman had some good recommendations there. A formal designation process will discourage questioning the validity of the diagnosis, as officers will have more confidence in the medical professionals authorized to prepare the form. So yeah, a better system is key. Expanding remote capability. So this is something they're really working on, which is video teleconferencing technology, where you go to one field office, but if you don't have enough officers there, you sit in a room and an officer in a different office comes and talks to you. So that's an interesting thing. The next segment is about denaturalization, a big push by the Trump administration, maintaining the integrity of the naturalization program. So they say in 2008, Customs and Border. Oh, this is interesting, because there's this big push for denaturalization. There was an Operation Janice that came up, which led to the opening of the field office in Los Angeles, which is just focused on denaturalization. This goes back to 2008, where Customs and Border Protection agents discovered 206 fingerprint cards on which fingerprints were printed for use in identity verification and criminal background checks that had not been uploaded into USCIS's digital fingerprint repository, and so were not accessible to adjudicators prior to granting immigration benefits to those individuals, including lawful permanent residents and for naturalization. Subsequently, other DHS components searched for and undigitized fingerprints, increasing the number of unrecorded fingerprints records to 315,000. This undertaking became known as Operation Janice. A DHS OIG investigation eventually determined that at least 1,811 naturalized citizens with final deportation orders or criminal records may not have had their fingerprint records in the digital fingerprint repository adjudicated during their naturalization application. So that was a serious thing, which eventually led to the creation of this denaturalization task force. Now they go into the history of immigration and citizenship, where originally one of the first immigration laws was the Naturalization Act of 1790 that said a free white person of good moral character residing in the U.S. for 2 years can take the oath, but they changed that a lot. The last significant piece of legislation amending naturalization procedures was the Immigration Act of 1990, transferring the authority to naturalize from the federal court, where it had resided for 200 years, to the executive branch, then the Attorney General, now DHS. So maybe we should take it back to the courts. On August 31st, 1995, INS announced the Citizenship USA program, promoting the benefit of citizenship with the goal to naturalize over 1 million applications within a year. That's a high goal. This program, CUSA, Citizen USA, had a big problem, because they said the FBI did not complete the criminal background checks for 18% of the cases. The FBI was unable to read the fingerprint cards for 124,000 applicants and did not receive another 61,000 of them. If the cards were classifiable, the FBI, this is sad but funny. If the cards were classifiable, then FBI conducted an automated search of its fingerprint repository, verifying any matches by manually comparing the applicant's fingerprint cards to the card on file with the FBI and providing the results to INS. Smudged, unclassifiable cards decrease the effectiveness of the automatic reader and the manual comparison of the fingerprints. And this is the part. If the name check result indicated the applicant had a criminal history, but the FBI could not verify the results through its repository, the FBI returned the unclassifiable cards to INS, legacy INS, with the notation, quote, no record based on name check, unquote. At this point, INS could have asked the applicant to submit a new fingerprint card, which INS would forward to the FBI at no extra cost to the INS. Unfortunately, INS interpreted the FBI's notation to mean that the FBI had completed its criminal history check and discovered no criminal record. Instead of submitting new cards so FBI could confirm individuals' identity and criminal history, INS went forward with naturalization and gave it. So it's kind of like a cartoon sometimes, but it's just human beings. This stuff happens. It's just that. The next part is about the challenge of decreasing USCIS affirmative asylum backlog, which is major. I don't have too many notes there. The origins of the asylum backlog, affirmative asylum backlog. There are many reasons why USCIS's affirmative asylum backlog has grown to over 350,000 cases awaiting disposition. Okay, so 350,000 cases. That's why I highlighted that for that stat. We all know what the situation is, a huge number increase, and there's more, review and all that kind of stuff. Next section is DHS Immigration Data Integration Initiative. I'm not sure if I took any notes on this part. And I think this is the last section or next to last, foreign students and the risks surrounding optional practical training. They put a lot of focus on this about, people from China come in and come expire membership, stealing information. I'm not really focused on that. It's more of the practical aspect for us, which is foreign students in the U.S., which there are over 1 million annually. So there's 1 million students coming in annually on student visas, probably decreased with Trump and stuff. But the percentage of all foreign students in the United States who participated in OPT in 2018, as indicated by ICE records, is more than 20%. So of those million that are here, it seems that I might not be doing stats apple for apple, but 20% of them are doing OPT. So it's a big population. Their stats here is a huge jump. So like in 2007, there's only 2 STEM OPT people. In 2008, it's 2,000. Now there's almost 70,000. In 2007, there was 25,000 OPT. Now there's 145,000 people OPT. So it's a huge program. It is alleged and is the subject of current litigation that employers are attracted to hiring OPT students by tax incentives aligned to the status of the students. We state no position on the litigation, but note that non-resident foreign students are exempt from U.S. Social Security and Medicare taxes on wages paid for services performed within the United States, as long as such services are allowed by USCIS and are performed and carried out. So because these foreign students don't have to pay those, the employer doesn't have to pay those extra fees for how they pay half the Social Security and Medicare taxes. So that's why. Now, the top 2 countries by total number of active students and exchange visitors and CVIS records in 2018 were China, 478,732, and India, 251,000. Post-secondary students from China and India represent more than 50% of the total international student population of over 1 million. And as you know, the visa bulletin charge for employment base are backlogged primarily for India and China. And so it's all these students that are here on OPT, later on get H-1Bs and then like. The National Science Foundation data on trends in doctorates in science and engineering fields demonstrates that of the 55,190 doctorate recipients in 2018, 17,124 were given to temporary visa holders. Over 1/3, 6,182 of those were from China, which is consistently the top country from which doctoral degree candidates originate. So let's say 55,000 doctoral degrees, 17,000 are temporary visa holders. Let me try to do some bad math. 1734, that's 68. So it's something less than probably 20% of our doctorates are going to foreign students. So China is the biggest one, then India, South Korea, Iran, and Taiwan. I can't say Iran because Iran, I can't pronounce it wrong, so Iran. I got to say Iran. But that's interesting. India, South Korea, Iran, and Taiwan. East Asia, South Asia are dominating the doctoral fields. And so that's an interesting stat to see there. Place of origin of most of the student visas, though, are China first, India, then South Korea, Saudi Arabia, and 5th, Canada. They have a list of, let me make a screenshot of this interesting list of the stats of the top 25 locations. It's interesting to see Saudi Arabia as number 4. They pay for the education. I remember when I was going to UCLA, there were a lot of Saudi students. Apparently, the Saudi government, all that gas money, they're paid for the student tuition. Both SEVP and DSOs are leanly staffed and yet have a significant set of responsibilities. ICE indicated in January 2020 that for the approximately 9,000 certified schools, K through 12 and universities, divided into approximately 60 regions, there's roughly 1 representative for each region. So that's one person dealing with all that from the government side. In 2019, approximately 10% of the Ombudsman's public engagements involve school-related stakeholders engaging with hundreds of DSOs across the country. DSOs also say that they are called upon, DSOs are designated school officials. These are the foreign international section of the schools that deal with the foreign students. They are called upon to explain the intricacies of immigration regulations to CIVA staff who may not have worked directly with international students. So the DSOs have to explain to the CIVA staff what's going on. And DSOs experience a relatively high rate of turnover. DSO noted a rate of 37% turnover in 2020 when fewer foreign students. So, you know, I've on LinkedIn, I've met some really good DSOs that are putting out good information. They really want to study and know this stuff, but I've met a lot of bad DSOs, unfortunately, that do horrible stuff and ruin their students' lives. So that high turnover shows as it is. Learning what's going on in the student visa program is so difficult. If they have high turnover, that institutional knowledge is going to disappear a lot. In fiscal year 2018, 3.37% stayed beyond their authorized window of departure of the students. At the end of the program, a total of 68,593 students. Broken down, 3.5% were F visa category, while 10% were M visas and 3.8% were J visas. The countries with the largest number of overstays were China with 12,900, India 5,000, and Saudi Arabia with 3,917. While the percentages of all foreign students who overstay is relatively small, the cumulative numbers are significant. Yeah, when you think there's 1 million students here and 68,000 of them, I mean, it adds up. Okay, so one of the observations Ombudsman put forward, this is a frustrating part because, you know, when you're going to get OPT, you're going to request an EAD with Form I-765. They say adjudication delays was a very short amount of time. One of the observations the Ombudsman put forward in the context of Form I-765 adjudication delays was a very short amount of time USCIS spends looking at such applications, which recently was confirmed by the agency. USCIS has determined the average hours per adjudication of this benefit, meaning the time an employee with an adjudicated responsibility actually handles the case, is 0.2 of 1 hour or 12 minutes. So it takes 12 minutes to review an I-765 for an EAD, yet we have to wait 6 to 8 months for like an adjustment status EAD, and OPT EADs went from being like 2 weeks to 2 months. I mean, what's going on? 12 minutes? I mean, how much are they getting large numbers of it? What's going on? They don't say the stats, but it's frustrating. In June 2018, DOS announced it would restrict visas for Chinese graduate students studying in sensitive research fields to 1 year while permitting annual renewals, but DOS has not identified exactly which disciplines are subject to this higher level of security. So then they go on to a lot of the security kind of stuff's the focus of this report, which I'm not going to go over. I'm going to go to the last section. InfoMod, year 2, accomplishments, lesson learned, and current challenges. So this is about this change in InfoPass appointments where we can't get them online ourselves. They say data from 2019 seems to indicate the program has met its stated goal to free up adjudication resources by steering inquiries to the self-help tools available to a variety of media. It is unclear, however, as to the specific time benefit recouped by the adjudications. Well, the reality is they say go to the website and the website has nothing, or they put you on hold for an hour until you give up. So that's not really a benefit. Stakeholders continue to report dissatisfaction with the program, however, citing wait times to speak to a representative and lack of knowledge among the initial representatives entertained. The InfoMod pilot was conducted for a period of 6 months, and the result confirmed that approximately 70 to 80% of in-person appointments were being used to make case status inquiries. So this is a serious issue, which I got to get into it, because pro se applicants just call the 1-800 number or do info passes to ask the most ridiculous kind of things, like where do I find the form, or like, because I get these emails all the time, and on my YouTube page comments like, I just submitted my case yesterday. How come I don't have my biometrics yet? It was like, well, wait a little bit. Like really, really bad questions. Let's see. So they go into the phone system. They say those who call between Monday and Friday from 8 a.m. to 8 p.m. Eastern, except for holidays, and navigate through the IVR are connected to a Tier 1 representative. Tier 1 representatives are not USCIS officers, but contract employees provided by a vendor supporting the contact center. Tier 1 representatives are provided 80 hours of training, including basic elements of immigration law, how to access USCIS systems, how to complete service requests, and use applicable systems, and how to navigate knowledge articles. So what's important here is like clients call USCIS hotline thinking they're talking to like an officer or someone who knows what they're doing, and they get bad guidance. And that becomes really frustrating when they do that, they mess up their case. Tier 1 representatives who determine that a caller's request meets one of the qualification criteria will create an SRMT for a Tier 2 ISO to review, and the caller is advised that USCIS will return a call within 48 to 72 hours to schedule the InfoPass appointment. The Tier 2 ISO is expected to make 2 attempts to return the call. But as a result, Tier 1, I skipping some stuff. They say as a result, Tier 1 staffing shrunk in late 2018 from approximately its expected level of 750 representatives to as low as 500 in January 2019. As of March 31st, 2020, there's 680 Tier 1. So they decreased the number of officers taking these phone calls, and that's why, I mean, it's weird. Sometimes I'll call and I'll get a hold of somebody really quick, and then the call gets cut off, and I call back, and it'll be like an hour wait, or I have an hour wait, and I hang up and call back, and I'll get a person in like 2 minutes. There is massive inconsistency as to the timeline of how to get a hold of an officer. And then there's a dependency, and that's about it. So thank you so much for listening. One last note I want to make about this. They have a chart on page 110 of 120 where it's a U.S. Department of Homeland Security organizational chart. And, the Department of Homeland Security was created after 9/11 as a way to, create better information sharing and organization to fight, terrorism. Now, how well they've done on that, how big a threat it actually was, so that's a political topic for another time. But the chart really shows you have the Secretary of Homeland Security, they have the Deputy Secretary, and instead of making some sort of pyramid system or multiple circles that, communicate together and send stuff, there's like 4, 8, 16, 20, there's 24 agencies that just directly shoot out of the Secretary's office. No organization. So it's kind of like being a person with a classroom of 30 students with all of them talking at the same time. I don't know what kind of system they're designing and made to think like that this is going to be better than what we had. But that really just puts it together as when you have a bureaucracy and system as big as we have to try to make decisions and things work fast, it's really hard to steer the ship. To move the Titanic around to avoid that iceberg is no easy task. And that's what we see with the Department of Homeland Security and even the dissatisfaction of its employees in all the reports that come out from the GAO. With that note, I want to thank everyone for listening to this program. If you haven't already, please like, subscribe, leave a 5-star review, and tell me what you like about it. Email me at info@immigrationlawyerstoolbox.com with your thoughts, comments, and if you want to get access to that magazine that's going to be coming out. With that, what else can we talk about? Well, yeah, that's about it. Thank you so much, everyone. Until next one, have a good one. Be safe. God bless. Bye-bye. Thank you for listening to the Immigration Lawyers Podcast. The Immigration Lawyers Podcast is a part of the Immigration Lawyers Toolbox, a training and marketing program for immigration lawyers. For more information about that, please email us at info@immigrationlawyerstoolbox.com. Also, you can find more information and updates on the LinkedIn page for the Immigration Lawyers Toolbox, as well as a private Facebook group for practicing immigration lawyers. You can email me for information about that as well. And also the Twitter page is a great place for updates. Until next one, have a good one.